an update in Karen Reed's case. Remember her, the 44-year-old Massachusetts woman who's accused of killing her Boston police officer boyfriend, John O'Keefe. Prosecutors allege that Reed hit O'Keefe and with her SUV left him to die in the snow. Defense argued that was a case of a mere cover-up, a massive cover-up. After 2 months, we heard this back and forth, and the case ended up in a mistrial. Jurors sent a note to Judge Beverly Canoni that indicating that they were at an impasse, that the future deliberations would be futile. And just recently, Reed's defense team said it received unsolicited communications with jurors who said they had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, the charges being second-degree murder and leaving the scene of a fatal crash. And as a result, the defense filed a motion to have those charges dismissed against their client. However, prosecutors in the case say they do intend to retry the case and that the defense motion, quote, lacks any merit or legal foundation. So I want to bring in my guests once again to talk about this, Krista Ramey and attorney Bridget Williams, both attorneys. Krista, I'll start with you. I find it really interesting, right? So the jury didn't come up and say not guilty for murder, not guilty for leaving the scene, But here's the question. Is that necessarily a not guilty verdict? Is that an acquittal? Even though they didn't come back with it, if they're saying this is what we decided, does the prosecution have a right to retry Karen Reed on this?
Right now, as we sit here today, yes, they do. A verdict happens in court, and this is hearsay evidence that is being, brought in to get it ultimately probably a motion heard and a hearing had. And what this judge does have is broad discretion. And we saw something similar to this in the Alec Murdaugh case when there was the question about whether or not the jurors were being, persuaded by the clerk of court. You saw the judge bring in all of the jurors and question them under oath. You could see something very similar happen here where the judge has discretion to call these jurors back into court, to question them and to get to the bottom of it. The fact that there was not further inquiries done during trial is astounding to me, because I've never had a situation where I've been in personally where jurors were hung and sent a note as such where there wasn't a little bit of probing about what's going on. And here they, it was just everyone just kind of took the jurors' word for it that it was on all counts, I guess. So it's confounding why they didn't talk to the jury and why the judge didn't even talk to the jury when she went back there. But she does have the discretion to fix this.
Well, Bridget, put it this way. Even if the judge or the court says, hey, listen, you know what, prosecution, you can retry her on everything. Should they? Right? I mean, after this, if this is the prosecution hears this, do they say maybe we shouldn't go for murder charges here? Maybe it was too much. Maybe we just stick with a manslaughter or something less than that. What do you think, Bridget?
Well, that sounds like it would be a great thing for them to do, but I have never seen where prosecution will decide they're going to change, their charges based off of that. I do think that the court has the discretion, just as the other attorney stated, is that the court has the discretion on if they are going to go back, have a hearing on this particular motion, and then question each of the jurors. Let each juror say, okay, well, we could not come to a decision. There was a mistrial. We could not come to a unanimous verdict. And then that will just make it so where this particular motion just dies at that particular point. So I think that the court would go back, ask each of the jurors for their specific, what they decided and what happened in that deliberations. And that's how they move forward there.
Well, now let's get very granular. Okay, Krista, let's get really granular here. Okay, so assuming this is true, the jurors say, we don't believe this was murder. We don't believe that she was leaving the scene. So now they seem to be kind of split on manslaughter. What theory are they going with here? Because I was struggling with this, right? I could say, okay, they don't believe she intentionally hit him with the car. Fine. But if it's manslaughter, are they saying, okay, she recklessly hit him with the car. She may not have, but we're also confident she didn't leave the scene, like she didn't realize she did it until afterwards. What would be a theory of the case that makes sense based on these purported jury notes?
Well, and then they've got the added complexity of the federal experts that were hired that their theory of the case of the going in reverse at 24 miles an hour and striking O'Keefe was not probable. The physics didn't match up, forces mass times acceleration. So you have that issue for the prosecution as well. So they would have to come up with a different way that her car may have struck him, maybe causing him to slip and fall, perhaps. I think that they would have to go back and do that actual testing on the soil to find out if it was in fact hard enough to cause the occipital fractures that they claimed were caused by the fall. I think they've got work to do. And, I think that they've got a problematic when it comes to their theory of the case. Now, with this focus group that they just had, that was, 9 weeks to give that focus group to them. They saw the defense's case. They know what they're up against.
Look, Bridget, you're a former prosecutor, right? So you look at this case, you say, how do we retry it a second time? What does their argument change? I mean, obviously the evidence is what it is, but they have to argue it, I would imagine, a different kind of way if they want to get a conviction against Karen Read. Although, I remember, and I think it was said so well in the Baldwin case, their job is not supposed to get a conviction. It's supposed to get justice. It's supposed to see where does the evidence lead us. If they have evidence that Karen Read didn't do this, they should drop the case. But real quick, we got a minute left. What's your take on how they should retry it?
I think they should go back, take a look over the evidence a little more with a fine detail, just to see exactly what they can produce and what they, can show. I do think that they have the evidence there to move forward with the involuntary manslaughter charge here. And so they can very well go back to that, go back and talk with the witnesses and talk about what things they can present in testimony. They have the grounds and they have everything necessary to do that.
Lot to talk about, as you can imagine. So this update comes after Alec Baldwin's case was dismissed on Friday. And remember, the actor-producer was on trial for the 2021 movie set shooting of cinematographer Helena Hutchins. Hutchins had died as a result of being struck by a live round that Baldwin seemingly fired on that set from a prop gun. Now, on Friday, the defense filed a motion accusing prosecutor Carrie Morrissey of failing to turn over pertinent evidence of live rounds possibly connected to the case. And Judge Mary Marlowe Sommer sided with the defense, ultimately dismissed the case with prejudice, meaning it can't be refiled. Now, this evidence was allegedly turned over during Hannah Gutierrez-Reed's trial, the armor on the set, and the 26-year-old, remember, she was convicted of involuntary manslaughter in March of this year, currently serving out her 18-month prison sentence. That's the maximum. And before I bring in my legal panel to discuss this, I want to give you a little bit more from Jason Bowles on his reaction to Baldwin's case being dismissed.
I haven't either in 30 years of doing this job. The judge did the absolute right thing, following the law and dismissing with prejudice when the state committed a pattern of misconduct that she found today, intentional misconduct. It was absolutely shocking that they moved the rounds into another case and another case number and then didn't turn them over to Baldwin's team. Absolutely shocking.
By the way, that was from an interview with Law&Crime's own Anjanette Levy that she did with Jason Bowles, again, after the case was dismissed. But Anjanette also spoke with Dutch Merrick. This is a prop gun set safety expert. And here's some of what he had to say about the issue that we're all curious about, how live rounds ended up on the set.
Well, firstly, there was something that came out where the prosecution has this theory or this mindset that if it's got a shiny nickel color primer, it could be linked to one of the rounds in question on set. And if it doesn't, it clearly is not. But in the testimony, it came out, Seth Kenney said, and he had told them apparently, that Joe Swanson he manufactured ammunition often with a variety of primers. It could be one of 2 or 3 different primers. So they knew that that wasn't a defining thing, that if it has a shiny silver colored primer, it's definitely one. If it doesn't, it's not. I mean, that's ridiculous. Now, how rounds get in, how they migrate to the set is anyone's guess, but I might offer this: if they were training actors for the 1883 on a private range, and they had the hero guns from that show, and they had a bucket of live rounds, and they loaded up the guns, and they're doing this for a few hours, and okay, that's lunch, or okay, we're going to go home, and you may have a revolver that is still loaded with 6 cartridges. That's how you get your number 6 on the set. And maybe that gun doesn't get emptied at the range, and it shows up in a gun bag back at the shop at PDQ Arms, and he empties it unconsciously, and those migrate as a group, and somehow they end up in a bucket full of dummies and in a box of dummies. It's a plausible possibility that it was just a slip up, because it's weird to me that there's 6 rounds on the set, 6 live rounds. that implies to me that they came out together from one firearm at one time. Maybe it was loaded and then unloaded as a group. So I can't, again, as sloppy and young and distracted as Hannah Gutierrez-Reed was on that set, it's hard for me to imagine she couldn't keep her live rounds separated from dummy rounds, or if she had live rounds anywhere near that process. So I give her the benefit of the doubt, and I'm seeing a lot of arrows pointing toward Seth's mishandling. Look at the way he kept his shop. Even though they were coming 39 days later to inspect his shop and to gather evidence, the place was a complete pigsty. I don't know of any prop house that I've ever visited that is as disorganized as that, especially not an armory that you're dealing with firearms and blank ammunition and dummies. That stuff has to be inventoried and very carefully organized, which those pictures show it was not under his care.
It seems we still don't even have a clear answer as to how those live rounds got into the set. All right, but let's talk about it. So my legal panel back with me to discuss. I'm joined once again by trial attorney Krista Ramey, but I'm also joined on set by Aaliyah Roberts. Great to have you both here. Aaliyah, I will start with you since you're new to the show, and a New York Law School grad, my alma mater. So I'm biased. I'm going to start with you. No offense, Krista. I will get back to you in a second. But Aaliyah, here's the thing that really, I was talking about it before, right? Big issue about not turning over evidence to the defense. But assuming it had been, right? Assuming this was in the possession of the defense, I can't tell if these live rounds that were supposed to be handed over helps Alec Baldwin's case, hurts Alec Baldwin's case. He wasn't tried for bringing live rounds. How could they have used this evidence to their advantage in that trial?
I thank you so much for having me, Jesse.
Yeah,
and of course, shout out to New York Law School, very exciting. So I think personally, if the evidence would have come in, right, if the live ammunition would have come in and Alec Baldwin would have been able to say, hey, listen, I have no reason to believe that there's live ammunition on this set. I've been an actor for 20 plus years. I've handled firearms for a very long time. And all of my years of handling props, there has never been live ammunition on this set, excuse me. So to the point of recklessness, there's no reason to believe that me as the actor, me as Alec Baldwin, I have no reason to be acting recklessly, even if the testimony came in that he was horseplaying, I believe, or there was something going on with the gun moving around. I had no reason to believe that these bullets were live rounds, because live rounds should have been nowhere near this set.
And it looked more like sabotage, right?
Exactly.
So here, and Krista, tell me if I'm wrong. Do you know how the live rounds got inside? I mean, we've had the trial of Hannah Gutierrez-Reed. Now we have this update about live rounds being brought in by Troy Teskey, who's the friend of Hannah Gutierrez-Reed's father. Do we have a clear answer as we sit here today on July 15, 2024, how the live rounds managed to get itself on the set of the Rust film?
No, and I think it's probably more unclear now. In fact, Jesse, I think that we can all agree on that. And that, that was not that big of an issue during the trial of Hannah Gutierrez-Reed. During her trial, there was definitely a dispute as to whether or not she brought those live rounds onto the set. It was a disputed fact that she disputed within her own defense and also through cross-examination. So the jury didn't need that to find that she was also just irresponsible and, reckless, and did so with reckless disregard for the human lives that were on that set. And so, how did that live round get into the weapon is the real question. And she was the one that was responsible for that. And that is, why I think that all of this other evidence about who brought the live rounds onto the set is not really material to her case.